Perhaps I would start with a bit of an introduction and with respect to my background, which may assist the audience in understanding how and why I'll frame my thoughts the way I do today. My experience relates to UN-mandated mechanisms, specifically commissions of inquiry, fact-finding missions, and examinations. So I have worked on Syria, South Sudan, Belarus, and Ethiopia. And in addition, I've also worked in the Golan Heights, Afghanistan, Iraq, and most recently, Ukraine. And as I was framing my thoughts this morning, there are two sort of qualifiers in the proposed title of my intervention that I was asked to address. And I wanted to sort of tease these out. One is the notion of Arab countries, and the second would be violations, or what constitute violations, and who exactly determine those violations in the present day context, and how that would be relevant for the arms transfer context. So if I can briefly begin with UN mandated mechanisms, over the past 2 decades specifically, the international community has embraced reliance on a series of regional and international efforts to investigate and document both human rights violations, including those that may amount to, quote, atrocity crimes, war crimes, crimes against humanity, and genocide, which we may all know. Similarly, over the exact same period, the number of non-international armed conflicts has more than doubled. And as a corollary, I think we have seen marked proliferation of non-state armed groups over that exact same period. So these efforts by the international community include the establishment of several permanent and temporary investigative bodies and mechanisms to document the facts and circumstances surrounding alleged violations, as well as to make legal determinations and often to apportion individual criminal and/or state responsibility. Commissions of inquiry and fact-finding missions that I have worked on over the past decade or so have been tasked with these functions and are established regularly by the Security Council, the General Assembly, and the Human Rights Council. Increasingly, the establishment of these investigative bodies involves consideration of both human rights and IHL violations, or of, quote, war crimes, either of which may include violations perpetrated by non-state actors, including sometimes corporate actors, which is also relevant in the arms trade context, whether or not language concerning corporate activity is ever explicitly mandated. I think typically member states establish these bodies to satisfy the need to have investigative entities that can report publicly on human rights abuses or, let's say, potential crimes against humanity during peacetime. When it comes to the context of armed conflicts, HRC investigative mandates frequently include specific language acknowledging IHL breaches, or again, indeed, the commission of war crimes. Moreover, it's the interpretation of these mandates that's left almost entirely to the individual entity itself. For example, the commissioners or independent experts appointed to the mandates, who decide not only on which actors to investigate, but also the extent to which arms trade may be investigated. So I guess a relevant question becomes, how do and how have these mechanisms reached findings on arms transfers? One important point is that systemic policies of state receiving arms, let's call them the recipient states, can be shown by a pattern of apparent violations. And you can reach conclusions about whether or not the recipient state should continue to receive weapons based on patterns of conduct. That means that you don't have to look into an individual attack necessarily, especially to meet the standard of proof for reporting that these mechanisms have, which I'll get into a bit later, but we can focus on patterns. So one thing we can focus on is, and which we have particularly in the Syrian context, is the pattern of not having military targets. So with the ICTY and the Kupicic case and the OHCHR, that's the Office of the United Nations High Commissioner for Human Rights methodology for these mechanisms, pattern conduct really matters. Repeated attacks amounting to, for example, incidental civilian harm may not always amount to recklessness. So the question becomes, can we infer intent from this conduct and then determine how arms may have been deliberately misused? Transferring weapons to a belligerent requires an ex-ante determination that these weapons would not have been used or would not be used in violation in the future. I would like to focus very quickly, if I may, on a thought that I had this morning on the future of the ATT and artificial intelligence models. So if we look at what's happening in Gaza and Israel at the moment with Absorba and Gospel for military objectives, or even the Lavender model to target individuals, particularly in their homes or with their families, this really bears mentioning. Where's the future of these kind of pattern conduct is going? Another question that arises is, would states bear an obligation to disclose their military objective? I mean, of course, ultimately, this is for courts to decide and not UN mandated mechanisms. But the evidentiary value of UN mandated investigative mechanisms may have a specific probative value there, as does the role of member states, because they have an obligation, as we all know, under the Geneva Conventions, specifically under Common Article 1. The high contracting parties undertake to ensure respect for the present convention in all circumstances. So I guess accepting the factual circumstances surrounding the intent of a belligerent misusing a transferred weapon, that is to say, using weapons in violations of the law, needs to be, quote, proven. Looking then at the organizational context or institutional context in arms transfers can be inferred overall by patterned or systematic conduct, which is something that these mechanisms are able to do. Briefly, again, turning to standards of proof, as again, we probably all know, the standard for arms trade differs from the criminal law standard of beyond a reasonable doubt. The arms trade standard is more akin to more likely than not. This is then similarly akin to the standard of these UN mandated mechanisms, which apply a standard of proof of reasonable grounds to believe. If we close our eyes and picture a sliding scale, if one were to imagine it this way, that's roughly a 51% probability. So if you have a 51% probability of understanding that it's more likely than not that these weapons will be misused, you likely have an obligation not to transfer the weapons. I just wanted to briefly also turn to the title of our webinar, as well as to my intervention, and discuss Arab countries. If we take the quote Arab world, at its minimum, it comprises some 20 states where Arabs form at least a plurality of the population. If that's the definition, then the list of modern conflicts in the Middle East, perhaps most prominently in recent history, and I'm talking only over the past 15 years, includes Libya, Syria, Iraq, Palestine, and Yemen, each of which there has been either a UN field presence, in the case of Iraq, or for which there has been an independent UN mandated mechanism, in the case of Syria, Palestine, and Yemen. Although the mandate for the group of eminent experts on Yemen lapsed in 2021, as the Human Rights Council politically refused to renew its mandate. Of course, for Libya, there have been two separate investigative mechanisms. The first Libya mandate was known for its finding that NATO conduct did not amount to concerted violations or weapons misuse. This is important later on for when we understand how these mechanisms are reporting on violations of conventional weapons. Another point I wish to raise is with respect to not only pattern evidence, which I mentioned, but domestic jurisdictions and sanctions. If we turn to the substantive contributions of these mechanisms and their reporting on weapons and indeed, quote, arms, it's perhaps pertinent to understand that the type of evidence they rely upon to determine potential violations of conventional weapons. In practice, the nature of Human Rights Council investigative mandates often involves interviewing witnesses, survivors, military and security defectors, and perpetrators, collecting, consolidating, analyzing, and preserving information and evidence. This evidence could include transcripts of in-person interviews, written statements, corporate records, contracts, government documents, and reports from NGOs, video and audio recordings, and satellite imagery. I wanted to give you a quintessential example of how that evidence has been used to determine how conventional weapons have been misused. In the context of Syria, while the notion of conventional weapons, which is our concern today, would by definition exclude nuclear, biological, radiological, and chemical weapons, by supplying conventional weapons, there have been several instances where these weapons have been used or indeed repurposed to be weapons of mass destruction. Now, I can only talk about my experience on the Syria Commission for 4 years with respect to what's in the public domain. Professional ethics would demand that from me. But there is a leaked report in the New York Times, and I'd be happy to reference that if that's okay for you. At least twice in 2018, the Syria Commission of Inquiry documented that the Syrian military fired Iranian-made artillery shells, which were filled with chlorine-like substances that oozed poison and gave victims few minutes to escape. Specifically, in paragraph 55 of that leaked report, for anyone who wants to look it up, I'd like to read it for you. In relations to the munitions used on 22 January and 1 February, the Commission obtained and assessed material evidence, including metadata analysis, and identified a surface-to-surface craft-produced rocket, which is known as an IRAM, or an improvised rocket-assisted munition. The Commission went on to state in the leaked document that IRAMs have been employed by a range of actors across Syria, though the particular design observed during these chemical weapons attacks is only known to have been used by government forces and rarely affiliated militias. Specifically, the IRAMs were built around industrially produced Iranian artillery rockets, known to have been supplied to the Syrian government forces. The particular examples documented that the Commission found bore markings indicated that they were produced in 2016, and the design features were consistent with IRAMs employed by Syrian government forces since at least 2012. So this is the type of knowledge and investigative documentation that commissions are able to produce at their best. Well, then the question becomes, how can we bolster the efforts of UN-mandated mechanisms and indeed civil society organizations such as Maat, with whom we're here today? And I think one thing we can all say is that documentation and open source investigation, as well as social media investigation, SOCMENT, they comprise a small community with weapons expertise. And I think we truly need to focus on how do we get these actors with weapons expertise and OSINT expertise to bolster the contributions of civil society as well as of UN-mandated mechanisms, so that way they can be a probative value to what conventional weapons mean in the context of the arms trade. I think I'll probably run over time here, so I'll just conclude that since its establishment in 2006, the Human Rights Council has initiated at least 40 of these mandated mechanisms, including commissions of inquiry, fact-finding missions, and other ad hoc investigations designed to address outbreaks of political violence, but more so also armed conflicts. These matters are constantly considered relevant and severe enough to merit falling under the purview of the Human Rights Council. However, again, do they have the necessary weapons expertise or the political will to discuss the nuances of how the arms trade is affecting concerned states, particularly when we discuss open source investigations and there is no access to the state concerned? Of course, Libya, Sharif Basuni was able to cross the border in the initial mandate, but with Syria, obviously there are other countries in which these mechanisms don't have access on the ground. So how do we identify those weapons? And I think if we go back to this Iran example of providing these IRAMs and how they were misused, it all goes back to OSINT, which is an extremely important, thing to underline. And then ultimately, these investigations and these findings can be shared with really competent jurisdictions, including national courts, those that are operating pursuant to the principle of universal jurisdiction, or again with the ICC outside of the ATT context. And they may also be used to provide reparations and prevent recurrence of violations. Thank you very much for allowing me to have that moment.